Hello, my name is Lanceiro, and I'm assistant professor in the University of Lisbon, and I work mainly on areas of EU law and also environmental law. So I've been studying issues of access to justice in terms of implementation of. So my presentation is on the triangle that has been created in terms of access to justice between three bodies that can control application of the Arras Convention: the Compliance Committee of the Arras Convention, the Court of Justice of the EU, and also national courts and access to national courts. This is basically my summary, but due to time constraints, I will explain it as I will go along. So a brief presentation of the Arras Convention. The Arras Convention is a convention made under the UNECE, so the United Nations Economic Commission for Europe, which is a specific UN body for Europe that also has the former USSR countries, Canada, the US, and Israel, and it establishes implementing general principles under the Rio Declaration and the Stockholm Declaration, general principles that are given to everyone, not even citizen, every person should have these rights. This is kind of the creation of the idea of environmental citizenship through a procedural way, in the sense that it's so hard to quantify, to specify what's inside of a right to a healthy environment or a right to an environment, that it's easier to just give procedural rights to people, in the sense that if everybody has access to environmental information and seek that information out, it will probably act in participation in decision making, in accessing to courts, while protecting that same environment. That is the underlying idea. The Arras Convention then, besides being the first environmental convention to actually attribute fundamental rights or attribute rights to, or recognize rights to persons, also is a pioneer in establishing a mechanism for review of compliance. It was already established in Article 15 of the Arras Convention, but that was basically a very broad, that should be a consensual mechanism of review of compliance. Teeth were given by the decision 1-7 of the meeting of parties, which created a compliance committee as a sort of para-judiciary organ where not only parties can do complaints. There were already 2 cases, and actually 1 case of a party that made complaints against itself, which is kind of strange. Referrals made by the Secretariat, none up until this point, but also communications made by members of the public, which is defined very broadly. And this is the major success. We've had 166 cases. Portugal haven't had the case up until now. Now we have a case before the compliance committee, and I'm really excited about it. The complaints can be made on a general failure of the party to act in accordance with the obligations of the convention, but also specific measures, legislative measures, for instance, but also specific events, acts, omissions, decisions. So the mandate is very broad, under which the compliance committee can make recommendations. Legit standing is defined very broadly, but there is a principle of exhaustion of domestic remedies, in the sense that no one can go to the compliance committee before first exhausting the domestic remedies available. And also, this is only a para-judiciary body, in the sense that the committee makes reaches conclusions and makes draft recommendations, and those recommendations must be accepted by the meeting of state parties, which up until 2017 always happened. Always the meeting of parties accepted recommendations by the compliance committee up until the point that I'm going to talk about. Okay, so the EU and the Aarhus Convention. The European Community became a member of the Aarhus Convention, then it became the European Union as a party. All member states are also parties, which kind of creates this triangle that I wish to talk about, in the sense that from them, not only member states are bound to the Aarhus Convention through regular or classic international law and regional international law, but also once the European Union has become a party to the Aarhus Convention, it also became a EU law obligation to comply with it. So we have two ways of controlling member state compliance, either through EU or through the compliance mechanism. This also means that the EU can be held accountable if it doesn't control compliance by the member states, which is also a novel way of seeing things. The EU implemented the Aarhus Convention on itself by the regulation, let's call it the Aarhus regulation, and also through directives. There is a specific directive on public access to environmental information. No specific directive was implemented to regulate public participation on decision making, but it was included in the revision of several specific directives, such as the Environmental Impact Assessment Directive, the Industrial Emissions Directive, the Seveso III Directive, and so on. It can be read upon the Habitats Directive, it can be read upon the Water Framework Directive, and so on. And in terms of access to justice, there was a proposal of a directive that failed because of subsidiarity questions that were raised, but as access to justice is sometimes equated or is it would take too long to explain, but access to justice as established in the Aarhus Convention is seen as a way to enforce each one of these rights. So if you ask for information and it's not given, you must have access to the court. If you don't have the right to participate in a decision or a permit, you have right of access to the court. And then finally, Article 9, number 3, so Article 9, number 1, 9, number 2, and 9, number 3 of the Aarhus Convention establishes right of access to environmental justice if there is a national legislation that is violated by a decision of the member state on environmental matters. And this is where the question may lie in terms of the EU. In terms of access to justice at the member states level, there is an extensive body of case law by the ECJ. I won't go into all of this, but the doors of the courts, especially, not really all the courts, for instance, in Portugal we have Axial Populares for environmental matters, so this isn't actually a revolution to us, but in countries which have a subjective scope of administrative review of administration, in the sense that it must be a violation of a right must be proven. For instance, in Austria or in Germany, this became really a revolution. Just to quote two cases, in the Slovak brown bear case, I cannot pronounce the original Slovak also, the court defended that an environmental NGO must have the right to go challenge before a court a decision, and that right must be achieved by the interpretation to the fullest extent possible of national law. And also, if national law doesn't facilitate that standing, that norm should be disapplied because of Article 9, number 3, and here we have a connection with Article 47 of the Charter, meaning that NGOs must be able to contest before a court a decision granting a permit. Due to time constraints, I will skip this. This is basically what I told you. So, the access to member states' courts is ensured by the case law of the European Court of Justice. But what about access to the European Court of Justice? Here we have the problem of the individual concern standing rule. Access to judicial review, as you all know, by the Court of Justice is established in Article 263. Then we have the problem of access by private persons, where NGOs are included, so Article 263, number 4. And the problem here is the interpretation, since the 60s, a very restrictive interpretation, the Plowman test, that has been consistently applied even in the case law on environmental matters, for instance, the Greenpeace case, and so on. So we apparently have a contradictory approach by the Court of Justice, which is very generous in terms of opening the doors of member states' courts, but not all that generous in terms of opening up its own doors. Still, not only saying that Article 9, number 3 doesn't apply to the Union on itself, so that it should be read as only an obligation to the member states on their own, which can bring us to accusations of the court of being two-faced or having a double standard. It's easier to open the doors of other courts than to open your own doors, and so on. This led to a communication by Client Earth, which is an NGO, to the Compliance Committee, to the Aarhus Convention Compliance Committee, complaining about actually the Aarhus regulation and very specifically the case law of the Court of Justice, in the sense that the case law has not evolved since the coming into force of the Aarhus Convention, which is kind of strange if you think about it, because it's kind of looking at an appeal, an indirect appeal procedure before a body of another international organization against the Court of Justice of the EU. The committee kind of did a first decision where it didn't really approach the question of the case law of the ECJ, stating that the case law has not fully evolved. Let's wait and see what happens to the case law after the real coming into force of the Aarhus Convention. But finally, in 2017, did find, after the evolution of the case law, its findings were that there was no evolution. Plowman was still being applied. Article 9 number 3 was still being read as not enforceable to the EU, and finally recommended the amendment of the regulation to bring EU into compliance with Aarhus Convention obligations. Here lies the surprise. For the first time, a party of the meeting of parties refused to approve the recommendation of the Compliance Committee, and that refusal came from the European Union. So it's basically, it's easier, the whole idea of leading by the example wasn't really here the case. Of course, this was masked under the fact that the Compliance Committee was accused of not bearing into consideration the constitutional specificalities of the EU, and that the recommendations were actually demanded a revision of the treaties, but which would be asking too much of the EU. That was not really correct, because as we've seen, the recommendation was merely to amend the Aarhus regulation. Of course, we can see that the court, being so restrictive in its approach, probably wouldn't, a revision of the Aarhus regulation wouldn't be enough. But anyway, this brings an end to a long-standing practice by Russia, by Kazakhstan, of always endorsing the Compliance Committee's findings. The first party not to endorse it was the European Union, and also the adoption of MOP's decisions on the basis of consensus. In the end, they agreed to postpone the decision on this case. Later on, the Council kind of brought himself to more or less try to respect the recommendations and used the mechanism of Article 241 to ask the Commission to make studies, and in the end, probably in view of the outcomes, propose an amendment to the Aarhus regulation by 2020, which is a long time, but it kind of gives me hope that the European Union will comply with the findings of the Compliance Committee. So, very briefly, we have here access to courts in environmental justice protected at three different levels. The Court of Justice has perfectly acted as a guarantor of access to justice in the national level, not as much in the European level. And we have the emergence of the Compliance Committee as a body that can review compliance not only of the administration, not only of the legislation, of the legislator of the parties, but also of the judge of the parties. However, the effects of this control are still limited by the willingness of the parties to actually comply with the recommendation. Let's wait and see what will happen at the European level. Thank you very much.